Okay, let's unpack this. When we talk about professions like doctors, lawyers, dentists, or engineers, there's this fundamental assumption we make, right?
Yeah.
That they possess some kind of impenetrable financial shield. High income means automatic stability.
Yeah, it seems logical.
But the research we've been reviewing, specifically these excerpts from the complete book on bankruptcy by Peter Francis Geraci of Geraci Law, tells a story that, well, it completely contradicts that whole financial myth.
It really does. It's a critical area, actually. We're looking at the specific financial pressures that high-earning professionals face.
Right.
Our mission today is really to pull out the key insights, not just why these individuals often end up struggling, but how U.S. bankruptcy law, we're talking Chapter 7 and Chapter 13, is actually designed to give them a viable path back to professional stability.
And look, since this is probably the first thing anyone in a licensed field thinks about,
Yeah.
let's just tackle it head on. We know this is the central question people ask. If you file for financial relief, are you risking your professional license, your career that you spent, 10, 15 years building?
That's absolutely the single biggest psychological barrier.
Yeah.
Stops people from even asking for help sometimes.
I bet.
And the answer, which we'll get into with specifics, is generally, well, it's reassuring, with one very important exception we really have to highlight concerning fiduciary responsibilities.
Okay, good. So let's start with that core finding from the Geraci Law material, this myth of financial insulation. The surprising idea here is that a degree, even one leading to a six-figure salary, doesn't automatically protect you from debt.
That's the harsh reality. The firm Geraci Law has represented thousands of people, doctors, dentists, lawyers, all walks of life, really. The misconception is that high income is some kind of cure-all.
But it's not.
No. The way these careers are structured, it almost creates a perfect storm for debt accumulation.
And we're not just talking about, running up credit cards, buying fancy
Right.
things. This is different. Here's where it gets really interesting. What are the specific financial burdens, the ones unique to these professionals, that can set them up for problems, even with huge earning potential down the road?
Well, it starts with delayed gratification, but also massive upfront cost. They carry immense debt loads before they ever see a real paycheck.
Right. Years of expensive schooling.
Years of schooling, yeah. Followed by student loan debt that often starts well into six figures immediately.
And all that time, the clock is ticking. While their friends maybe started careers earlier, earning, saving.
They were incurring debt. And then it gets amplified by the requirements of their specific field.
What kind of requirements?
Think about the really expensive startup and overhead costs. A new dentist buying all that equipment, or a lawyer setting up their own practice.
Okay, yeah.
Licensing fees, practice insurance, specialized software or equipment. It adds up incredibly fast. So you've got that delayed start to earning real money combined with these massive loan payments.
So even when they finally hit that, say, $300,000 income level.
Right. Even then, they can be so far behind that the debt is already spiraling. It's overwhelming. And then you layer on normal life stuff, family expenses, taxes, which are significant at that income level. They can find themselves on really shaky financial ground surprisingly quickly.
That leads us to what the source material calls the double burden. If a professional is already carrying this huge initial debt load, what are the two specific debts that are the most persistent, the most difficult, the most stressful, the ones people think bankruptcy maybe can't even fix?
Yeah, looking across the sources, the biggest pain points that keep coming up are chronic tax debt and, of course, student loans.
Right. The two untouchables, supposedly.
That's the common wisdom, yeah, that they're nearly inescapable. You usually can't just discharge them in bankruptcy like, say, credit card debt. But this is where professionals really need to understand Chapter 13.
Okay, so Chapter 13, that's the reorganization one, not the liquidation one.
Correct. It's a repayment plan.
So it can still offer real help with these two giants, taxes and student loans, even if the debt itself isn't just wiped clean away.
Absolutely. What's really fascinating here is the specific relief offered for what are called priority debts, like tax debt. If you file a Chapter 13 repayment plan, the money owed to the IRS or state tax authorities can often be paid back, get this, without interest. Over the life of the plan, which is usually up to 5 years.
Hold on. Paying back taxes with zero interest, that's huge.
It's a monument.
Because if someone has fallen behind on taxes, the penalties and interest just compound like crazy, don't they?
Relentlessly, it is a massive benefit. If you've been struggling for years, it's not uncommon for the IRS penalties and interest to actually exceed the original tax amount you owed.
Wow.
Chapter 13 basically stops that clock. It lets a high-earning professional reorganize their whole financial life, consolidate other debts, and crucially pay off those crippling tax obligations in a structured way, freezing the interest. That's why it's so powerful for people who have the income but just need time and structure to stabilize.
Okay, that makes perfect sense for someone with consistent high income who just needs breathing room from that runaway interest.
Mm,
But what if someone's debt is just truly massive? They can hit a ceiling for Chapter 13, right? There are limits.
They do, yes. Eligibility for Chapter 13 is critical, and it's strict. The law puts caps on the amount of debt you can have and still use this chapter.
What are those caps roughly?
Right now, they're roughly $1.3 million in secured debt. That's debt tied to an asset like a mortgage on a house or maybe expensive medical equipment.
Okay.
And roughly $325,000 in unsecured debt. That's things like credit cards, personal loans, and importantly, most student loans fall into this category.
So if you're a professional, maybe a doctor with multiple huge student loans from undergrad, med school, residency, plus maybe some practice startup debt that's unsecured.
Mhm.
Once you cross that $325,000 unsecured threshold, Chapter 13 is just off the table,
Huh.
regardless of your income.
Precisely. It doesn't matter how much you earn at that point. You're over the limit for Chapter 13. They then have to look elsewhere, most likely Chapter 7, which has entirely different rules and implications.
So the lesson is,
Yeah.
keep an eye on those numbers. They really dictate your legal option.
Absolutely. They dictate the strategy.
Now, let's circle back to that license question again, because I still think it feels counterintuitive for a lot of people.
Understandable.
If I'm, say, a dentist who has somehow racked up $500,000 in consumer debt and just failed to pay it,
Mm-hmm.
why wouldn't the State Board of Dentistry see that as, professional irresponsibility? Why wouldn't they flag that?
It's an excellent question, and it really hinges on understanding the different purposes here. The purpose of bankruptcy law versus the purpose of professional licensing boards.
Okay.
Bankruptcy law is fundamentally designed to help the honest debtor reset their financial situation, to give them a fresh start so they can remain productive members of society. Most licensing boards, medical, dental, legal, border, their primary concern is your ability to perform the duties of your profession ethically and competently. Can you treat patients safely? Can you represent clients effectively?
So financial hardship isn't automatically seen as a moral failing that impacts competence.
Generally, no. It's usually viewed as a financial problem. Boards tend to understand that financial circumstances can be situational, maybe triggered by illness, divorce, a partnership dissolving unexpectedly, things that don't necessarily reflect on your ability to practice your profession. They don't typically revoke credentials just for being financially unfortunate.
Okay, that's a relief to hear. But you mentioned an exception earlier.
Right, and this raises that important distinction, the financial sector. The one major exception is if your profession involves managing other people's money, a fiduciary role.
Like a stockbroker with a Series 7 license.
Yeah.
Or certain types of financial advisors.
Exactly. For those professionals, the regulators FINA, the SEC, take the handling of client funds incredibly seriously. Filing for bankruptcy, especially a Chapter 7 liquidation, could very well trigger an immediate review or even potential revocation of their license.
Why the difference?
Because it speaks directly to their perceived financial reliability when they're entrusted with the public's money. That's a fundamentally different kind of trust relationship than, say, a doctor-patient one.
Okay, that makes a clear boundary then. So outside of those specific fiduciary roles, the real risk isn't the bankruptcy filing itself. It's dishonesty around the bankruptcy.
Absolutely. That's the key takeaway. The bankruptcy system is built to help the honest but unfortunate debtor. What truly puts your license at risk, and frankly it could lead to much worse, like criminal penalties, is if the debts you're trying to get rid of were incurred through fraud or misrepresentation or some kind of intentional wrongdoing.
Like lying on a loan application, maybe?
Yeah, exactly. Or running up huge bills knowing you couldn't pay right before filing, things like that. And then you lie about those actions during the bankruptcy process itself. That is serious unethical conduct, and professional boards will take notice of that. Honesty, transparency. It's everything in this legal process. Being unfortunate is one thing, being crooked is another.
Got it. Okay, let's pivot slightly to the self-employed professional. The doctor or lawyer running their own practice. They often deal with those feast or famine income cycles that maybe their salaried counterparts don't experience as much. What specific financial triggers tend to push them into trouble?
Oh, self-employment adds a whole layer of volatility. Absolutely. Things like relocating the practice, the sudden loss of a key partner, a serious personal health crisis that stops them from working.
Right, income just stops.
Or even just mismanaging things, underestimating tax liability, not keeping enough cash reserve for slow periods, practice overhead getting out of control. All these can lead to rapid financial distress. Their income often isn't stable month to month, and businesses' success is totally tied to their personal health and ability to generate work.
So if they hit that kind of instability and they need to reorganize, maybe through Chapter 13, the sources point out three common problems they face that can make that specific process difficult for them.
Yeah, there are definitely hurdles. The first big one is simply having insufficient income to propose a realistic plan. You see, a Chapter 13 plan has to show the court and the trustee that the professional can cover their ongoing living expenses and pay something meaningful back to their creditors over the plan's life.
And if the numbers just don't add up, if their projected income minus expenses doesn't leave enough,
Then the trustee likely won't recommend confirming the plan, and the judge won't approve it. The math has to work.
okay. And the second problem ties right back into that income volatility you mentioned, the big swings.
Exactly, that's income instability. Courts and trustees really expect predictable, consistent monthly payments in a Chapter 13 plan. If a lawyer, say, brings in $5,000 one month but $40,000 the next, how do you structure a consistent payment? It's almost impossible to maintain that consistency over 3 to 5 years. And if payments are missed, the whole plan can get dismissed.
Right. The court wants predictability.
Predictability is key for Chapter 13.
And the third problem, this sounds like maybe the most frustrating one for some high earners. It's like being caught in limbo between the two main bankruptcy chapters. They earn too much, but they also owe too much.
Precisely. That's the frustrating spot. They might earn too much income to pass the means test for Chapter 7.
Okay, wait, let's just quickly clarify the means test for listeners. That's the test designed to see if someone can afford to pay back some debt, right? To prevent high-income folks from just wiping everything out in Chapter 7 if they don't need to.
Exactly right. The means test looks at your income compared to the median income in your state and calculates if you have enough disposable income left over after certain allowed expenses to make payments to unsecured creditors. If you earn too much, the law basically presumes you should be in Chapter 13, repaying at least a portion of your debts.
Okay, but the self-employed professional we're talking about gets caught. They earn too much for Chapter 7 according to the means test, so the law says go to Chapter 13. But then they find out their debt total, especially that unsecured debt, is too high for Chapter 13's limits, so they're stuck. Too much income for 7, too much debt for 13.
That's the structural gap they can fall into, no obvious path forward within the standard framework.
So what happens then?
Well, this often leads them, perhaps counterintuitively after failing the means test, back towards Chapter 7, but approach very strategically.
How so?
If the professional practice itself, the actual business entity, its assets like equipment, accounts receivable, goodwill, if it has little to no real liquidation value, maybe the equipment is old or leased, there aren't many outstanding client payments owed, or the practice value is tied entirely to the professional themselves,
Yeah.
then Chapter 7 might still be the practical solution. It allows them to wipe out that crushing, unsecured personal and maybe business debt while leaving their core professional ability to earn income intact. They can basically keep working, keep generating income, but without the old debt dragging them down.
That's a really crucial insight. Bankruptcy can wipe out the debt, but preserve the profession, the ability to earn.
It really changes the perspective, doesn't it? The sources really emphasize that seeking this kind of reset isn't failure. It's often a strategic professional move. Once professionals are freed from that unmanageable debt burden, think about it. They're less distracted, less anxious. They can focus better. They become more effective in their practice. It can lead directly to a kind of professional renewal and ultimately better service for their clients or patients.
That is a powerful way to frame it. Not an ending, but a reset. Let's quickly recap the essential advice then. For any professional listener maybe contemplating this complex path, pulling together these insights from the Geraci law analysis.
Okay. First and foremost, honesty is everything. Be truthful, be accurate in your bankruptcy filings. The system is designed to protect the honest debtor. Deception is where the real trouble starts.
Right. Second, your license is rarely affected. Unless you're in that specific fiduciary financial sector we discussed, or unless there was fraud involved in how the debt was incurred or handled, your ability to practice medicine, law, dentistry, engineering, it generally remains intact.
Third, know the numbers. Especially those Chapter 13 eligibility thresholds for debt, the $1 3M secured, $325K unsecured. They are hard limits. If you think you're getting close, get professional advice immediately to understand your options.
Good point. And finally,
Finally, and maybe most importantly, understand that debt problems are fundamentally financial problems. And financial problems, however overwhelming they feel, usually have legal solutions. They're not necessarily career-ending events, nor are they an automatic reflection of your professional character or competence.
excellent summary. So today we really covered the unique financial traps that even high-earning professionals can fall into, from that double burden of tax and student debt to the tricky eligibility rules of Chapter 7 and Chapter 13, all drawn from the analysis provided by Peter Francis Geraci of Geraci Law.
It's a complex area, but understanding the options is the first step.
Absolutely. And for a final thought today, something for you, the listener, to consider. Given that we've seen how high student debt and maybe inherent income instability are almost built-in challenges for so many demanding high-earning professions today, consider this. How might the threat of financial instability and just the massive grinding stress that comes with it, how might that affect the quality of service provided to clients or patients before a professional ever reaches the point of seeking formal help? That financial stress,
Yeah.
it doesn't just damage the person's balance sheet. It surely impacts the focus, the care, the attention they're able to give every single day on the job. Something to think about.